You're charged with harassment of a public servant as a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Welcome to Elite Justice Network.
2021 CR 7768, State of Texas versus Wendy Rathbone. Do I have the parties announced for the record for the state?
Debbie Cruz on behalf of the state.
Defense.
Eric Hernandez for the defendant, Wendy Rathbone.
And are you Miss Rathbone? Rathbone. Okay, thank you. Mr. Coates, are you able to, Deputy, can he?
I'll start.
No. You can just move him down to that end.
And Judge Daniel Escobar for the state to begin.
Right. Counsel, you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Rathbone, I'm showing you what's entitled Application for Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We waive, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we're proceeding on count 1 and waiving count 2.
Any objection?
None whatsoever.
Ms. Rathbone, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review those documents with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with harassment of a public servant as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea bargaining agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargaining agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do believe so, Your
Do
Honor.
you believe she's currently competent and was legally sane at the time of the offense?
In my opinion, yes to both.
Ms. Rathbone, has anyone get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on count 1. They're asking that your punishment be assessed at 2 years in the prison. There's a $1,500 fine. The state recommends community supervision, and they're asking for a mental health evaluation. Did you understand that to be the plea?
Yes, ma'am.
Defense is at the plea.
It is, Your Honor.
State is at the plea.
Yes, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
None, Your Honor.
Next, I'm showing you outside the plea. State is requesting that your community supervision be for a term of 3 years. There'll be a TAP evaluation, 120 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to count 1 in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
State offer states to the one and all attachments.
No objections.
Ms. Rathbone, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
I'm sorry, sign it in all the appropriate places.
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments and review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are we proceeding with sentencing?
She was, Your Honor, and if I just speak to the court about the fine in her residence.
All right, well, the court will probate that. So with regards to residents, what's,
Ms. Rathbone is currently living in Las Vegas, Nevada. That's where she was picked up on this warrant and extracted back to Bear County. So we'd be asking if she'd be allowed to report to probation from Nevada, or that her probation be transferred to Nevada.
all right, what county is that?
Clark,
Clark County.
Okay. Who are you living with there?
my boyfriend and I,
Who's this boyfriend?
we've been together 3 years. And Ralph, we don't.
Okay. Do
And
you
I
have
just-
any children?
I have 2 children, one 22 and one 11.
Where's the 11-year-old?
I'm not divorced yet, living with my husband in San Antonio.
Okay, so the 11-year-old is in San Antonio with your husband.
Right. But we've been legally separated for quite some time.
Okay. Yes.
And Your Honor, I did speak to Mr. William, her paramour this morning, and he did confirm the address.
All right, I always find that people on the civil side always call them paramours. Is that just something we like to say?
That's the preferred term, I think, in family court, when there's somebody who's living with a
Yes.
partner but still married.
Yeah, no, I mean, no, they use it for everything. I never see boyfriend. It's always paramour. It doesn't have a nice ring to it, I always thought. But that's just me. So, are you employed?
No, man, I live off disability.
All right, what's your disability for?
Mental illness.
All right, so are you seeing someone in Las Vegas for your mental health issues?
Yes, ma'am. I have a primary care position, but I'm on the waiting list to get to behavioral. But since I've been in jail, I've been back on my Prozac, and it's helping a lot.
All right, so how's she going to get to Las Vegas?
I believe Mr. William is currently here because he was inquiring about when she would be released.
All right, where is Mr. Williams?
He's at grandma's house, but
Oh, so he's not in the courtroom.
no, he's not.
Okay. Probation, what are we going to do about this transfer? How long would that take?
Honor, it's by permission for her to leave with the travel permit. In the meantime, I cannot answer specifically how long it would take for the transfer. Because they have to, the receiving state has to approve it.
All right, I'll give her permission to travel to Las Vegas. Any objection from the state?
No, Your Honor.
All right, so this is what the court is going to do. The court is finding you guilty. Court will give you permission to travel to Las Vegas. While in Las Vegas, there's to be weekly reporting to probation by Zoom until transferred. And I'm going to request a transfer to Las Vegas. The only reason why I'm letting you transfer there, based upon what your attorney is telling me, it appears that you're receiving treatment there and you're stabilized there. It's to be continued. Who is your caregiver out there?
I don't have.
What's your doctor? Well, what's the doctor's name?
Oh, DB Omar, it's the primary care physician. And I was getting it transferred to mental health solutions.
All right.
So I
So,
can prove all that, once I'm back home. I just don't have any of this stuff here.
there's to be continued treatment with the primary care physician. I want a MIC evaluation that can be done out of custody. And you're to provide probation with documentation of your the person who's providing you mental health treatment.
Okay.
And in Nevada. Off the record for a moment. Caroline, I'm sending you the signed documents on Mr. Chrisman.
Okay.
And Mr. Chrisman, I'm going to put you back in a breakout room so that, Caroline, do you prefer to do it through a breakout room or do you?
Yeah, I can go in the back.
All right, I'm going to send you to breakout room number 2, Mr. Chrisman, and they'll go over your paperwork with you. Back on the record. So we're going to do a MIC evaluation out of custody. I want a TAP evaluation also out of custody. And there is,
Watch what's happening here because this may sound like small talk, but it's actually something courts frequently examine during probation decisions. Judge Boyd isn't simply asking where someone lives or who they're living with out of curiosity. She's trying to understand the environment this person is returning to after leaving court. Probation isn't just about signing paperwork and staying out of trouble. It's about whether someone has structure, treatment, support, and stability around them. That's why the questions begin expanding beyond the charge itself. Let us know in the comments. Should a judge consider a person's home environment and relationships when deciding whether they deserve a second chance? This is where many viewers may misunderstand what they're seeing. Some people hear probation and immediately think someone avoided prison. But listen carefully to the conditions being built here. Weekly reporting, mental health treatment requirements, evaluations, community service, employment verification, travel restrictions, and continuous supervision. Judge Boyd isn't handing out freedom with no strings attached. She's creating a tightly monitored structure designed to reduce risk and increase accountability. That's a huge distinction because second chances in court often come attached to responsibilities that can completely reshape someone's daily life. This courtroom hearing ultimately became about much more than a harassment charge. Judge Stephanie Boyd balanced punishment with rehabilitation, focusing not only on the offense itself, but also on mental health treatment, long-term stability, and future accountability. The court imposed a suspended prison sentence and strict probation conditions, creating a path forward while making it clear that future violations could bring serious consequences. The biggest message from this hearing was simple. Second chances are opportunities, not guarantees. What do you think? Was Judge Boyd too strict, too lenient, or exactly right? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe.